Hello, my name is Mike Tessara and I've prepared this ACCC cheat sheet and I'll be looking at January 2025. For those who haven't seen these before, it's effectively a summary of all the ACCC activities in January for a particular month. And for those who do watch these regularly, I have fallen behind a bit. Late last year, there was so much going on. So I've actually sort of caught up now. This is for January 2025 and I'm doing it on the 19th of February 2025, so I'm not too far behind. Okay, so a bit of background about myself. I'm a competition consumer lawyer and I've been running my own practice of sale legal consulting for the last 18 or so years. And I help individuals and companies with competition and consumer law matters. I also do a bit of legal expert work for some legal publishers, LexisNexis and CCH and competition and consumer law matters. And for a part-time gig as a general member of the Commercial Consumer Division of NCAT, New South Wales Civil Administrative Tribunal, and that's a good role in the sense that I get a chance to actually look at consumer law matters and make decisions about them. So I get a first-hand experience there. Prior to that, I worked at the ACCC for 15 years in a variety of roles in enforcement and mergers. Outline looks quite long, but actually there's only a couple entries under some of them and no entries under others. So courts, there was one case, full federal court case, no enforcement action, no mergers, one very big scam announcement, a couple of authorisations, a notification, which is a bit unusual, another access matter, so that's two in 2 months, so that's very unusual, one inquiry, other is really some staff movements and a couple of people leaving the ACCC, and then I finish with some commentary. Now, the case in January 2025 was Altitude. This was actually an appeal against a contempt finding by Justice Bromwich. So it went to the full federal court. And on 28th of January 2025, the full federal court dismissed the appeal by Altitude. And Justice Bromwich had found the contempt proven and had imposed a fine of $1.5 million. Now, the interesting thing here, the earlier case involved allegations of breaches of the Australian Consumer Law and the Franchising Code, allegations that weren't complying with particular obligations in terms of, for example, the release of marketing fund statements and things like that. So there were some of the franchising code breaches. But the other breach that was interesting was an allegation that Ultratune at least failed after the hearing to comply with its obligations under the compliance program. So the first case was resolved. There were orders obtained by the ACCC requiring Ultratune to do certain things and also to implement a compliance program. So the ACCC has alleged in this case that Ultratune failed to comply with its compliance program obligations. Specifically, there was an obligation for the compliance officer to give reports to senior management at Ultratune 6-month periods, I think it was, or maybe more regularly, explaining the effectiveness of the compliance program, and he or she failed to do that. So the ACCC alleged that was a breach of the undertaking, of the order, and accordingly contempt. Now, Ultratune appealed the contempt finding of Justice Bromwich on a couple of grounds. The first was they claimed the court had no power to impose a punishment for contempt where no endorsement was included on the relevant orders as to the consequences of non-compliance. Now, I don't quite understand that as a ground of appeal. Like when I read that, I think, well, maybe that's relevant for an individual party, but I don't see that it's something that would apply to a corporation. So they went down on that one. And the other one they argued was that the way the fines which Bromwich imposed had been calculated was wrong. Again, I didn't think that was a very strong ground of appeal. It seemed to me the strong ground of appeal was, we're sorry, we expressed contrition, and $1.5 million is too much. That seemed like the better appeal grounds to make, but I don't think they ran those arguments. Anyway, it's an important case in terms of enforcement of the obligations to comply with the compliance program. The court case here isn't one that actually had a decision in 2025, but it is a big case of a lot of skirmishes in the end of 2024. And I thought I'd cover it here because it's going to be the big case in the next couple of years. ACCC sued MasterCard, alleging that they implemented a bit of a plan to try and subvert the least cost routing initiative. So the Reserve Bank decided to introduce this least cost routing initiative, which aimed at increasing competition by allowing merchants to choose the lowest cost network to process their transactions. So they could choose whoever they wanted. That obviously better for the businesses, better for the consumer. And that meant that the merchants could choose Visa, MasterCard or EFTPOS. And the thing there was EFTPOS is the cheapest. So I guess There's probably definitely MasterCard, but maybe Visa always sees a bit of risk there that merchants are going to be electing to use EFTPOS as their debit credit card payment system. So what the ACCC's alleged is that MasterCard tried to lock in 20 of the biggest major retail businesses in Australia to an agreement with them whereby they'd be using MasterCard debit and credit as a default, and therefore allegedly excluding competitors, specifically, I guess, Visa and EFTPOS. So that's the allegation, and that's a big case. And the MasterCard's been finding it very hard. The most recent skirmish has been in relation to a novel issue that under the Reserve Bank Act, Section 85, there's a provision which says that courts are permitted to take judicial notice of Reserve Bank publications. So that means you can sort of accept them as fact or gospel or whatever you want to say. So you don't need to inquire as to whether it's true or not. And MasterCard definitely doesn't like the fact that these publications are going to be able to be used in that manner, and they've been desperate to try and get them. Get a ruling from the court that they're not going to treat it as giving a judicial notice, and so they went first. I think they were first in front of Justice Lee, and they were knocked back, and then they appealed, and they were knocked back a second time. So obviously, I think it might go to the High Court, or at least they'll speak special leave, to sort of argue that these Reserve Bank publications should not be in a position of a court having to take judicial notice of them. I just can't see they'll be successful. The section looks pretty clear to me. But it's a big case. It's been dragging on a lot, using a lot of resources, both for MasterCard. I think they're using Baker McKenzie, so a lot of people over there working on it, and I'm sure lots of people at ACCC working on it. And the trial date was supposed to be 2025 in front of Wigney, but it's been kicked back to 26, so it's going to go for a long time. Don't think it's going to settle. No enforcement actions announced in January 2025, which is very surprising. That's unusual. And I think there was some concern expressed that maybe the ACCC is dropping off on enforcement. Most of the concern is about competition law cases. Having said that, the main thing is that when the Spotless Ventia alleged cartel case was announced last year, some people commented that was like the first competition case filed by the ACCC in 400 days or something. And as you can see at the bottom there, ACCC only filed one court case, competition law case in 2024. So people are saying, hey, what's happened to competition law? It's dropped off. The ACCC responded by saying we have a robust pipeline of ongoing antitrust investigations. So they're saying they've got plenty coming through and it's going to be business as usual. Robust, I don't know why people use the word robust. Seems like a strange word to use anyway. But and they also said the fact we only took one case in 2024 doesn't mean we're changing our priorities. And I think here there's an element of I think Gina Cascov is very thorough, meticulous. I think she'll be trying to choose cases that have merit and also are going to have a big impact in the market. So maybe she's a bit more selective than some of the previous chairmen. I know that some of the cases that were run in the past and the competition law were pretty bit of a waste of time, or one case, I won't mention the particular case, but it fell over when the court concluded that the company didn't have market power under Section 46. Now that's a threshold issue. You should never fail on a misuse of market power case on the company having market power. That's a bit embarrassing. So I think that's the thing. I think Jen's probably being careful, and the cases that she'll run, ACCC will run under her, will be big impact cases. No merger activity in January, and that's also not surprising for a couple of reasons. Firstly, there's been a lot of activity at the end of 2024, a lot of ACCC oppositions and a lot of, I guess, constructive responses from merger parties saying, okay, you've identified the competition issues. What about we sell these assets off? Will you be happy with that? And ACCC said yes. So ACCC is getting, structural divestments, structural remedies through divestments to solve competition issues, which is the best outcome, I think we all agree. And so a lot of matters were knocked over last year, not many two new ones coming through. The other reason I think there might not be too much activity in January and going forward is because the new laws have come in. I think parties are a little bit confused about the way they're going to operate, thinking about whether they maybe delay a merger, wait for the new merger laws. And there's actually a funny provision where even though the laws don't come in from until a particular date, parties do have the option of using the laws early, which I find quite strange, being able to use laws before they sort of come into effect. So there's an option to use the law early, and so that's obviously creating a bit of confusion amongst merger parties saying, well, should we just stick with the existing system, or should we elect to use the new system early, or shall we just wait till the new system's in? So a few interesting decisions for people to make. One issue that I thought might be interesting to raise here is that I had a incident recently where I did hear through the grapevine that a particular, and this is in the context of a compliance program audit, that a particular organisation, who I won't mention, got the particular work after telling the client that they would do a light touch audit. And I thought, oh, that's not good. You know, it's like saying to the party, well, I'm not going to really do a very thorough job, so hire me, I'll be cheaper, and you know, the implication I got to work for that reason. And I think this is where maybe the ACCC needs to take a leaf out of the Department of Justice or the Federal Trade Commission's book. Those organisations are much more active in seeking to ensure the right person is appointed to act as, they call them monitors, compliance monitors, or you know, auditors of a divestiture, much more active. And I guess, you know, maybe I blow my trumpet here, but the FTC, DOJ often agree upon a person going in there who's a former official from their organisation who's gone private, which is my situation. Maybe I'm just trying to get a bit more work out of here, but I think that there's a concern that maybe some of the people that are going in and doing this work are not doing it thoroughly, are also maybe seeking to get ongoing work with the particular client, and maybe not doing the thorough job. So I think the ACCC has to be more active in this area and make sure that the people who are being appointed to these roles, because ACCC does appoint people to, you know, particular divestment roles, that they're going to do a thorough job. A big scam matter that happened in January 2025 was actually this joint investigation called Operation Firestorm, which involved Australian Federal Police, National Anti-Scam Centre, basically ACCC, Philippines Presidential Anti-Organised Crime Commission, the National Bureau of Investigation. And they got together a big investigation into this massive romance scam being run out of the Philippines. And they did raids, and as you can see there, they did some raids. They got 300 computer towers, 1,000 mobile phones, and a bunch of SIM cards. And on those particular hardware, there was all these details of individuals who were the targets of this particular romance scam. And of all the people they got, 5,000 were Australians, maybe mainly Australian men, I've got to say. And so what the task force decided to do was to send text to all the victims, probably all the victims all around the world, 5,000 victims in Australia, potential victims, tell them, hey, you guys are actually involved in a scam. Sorry to tell you that. You thought you had found the perfect person for you, but unfortunately you're being scammed. Now, I guess the big thing here is the way it works. You know, the scammers using popular online dating apps trick victims into fake online romantic relationships, and they convince them to sort of start handing over money. Okay. Now, the very strange word used here by the ACCC in the press release, they would request a minimum first investment between AUD of $300 to $800. It's funny, investment's a funny word, a very cold word, but really it's not really accurate, because what happens here, form a romantic attachment, somebody maybe a bit lonely, then the scammers start saying, oh, I've got a problem, you know, I'm unemployed, I'm sick, I'm in a violent relationship, could you help me out with some money? And then they, out of the, kindness of the heart, send them some money. So I don't think investment's the right word. And then obviously once the person gives a bit of money, they try to encourage them to give more. And I guess ultimately they might be trying to get into the account details, take all their money. And as you can see, the targets here, men over 35, like I'm over 35, but I haven't scammed yet. And the fraudsters often pose as Filipino females working in Australia or local female resident in the Philippines. So this is big time organised crime. It's a lot different to when I was at the ACCC. We used to joke about the white shoe brigade from the Gold Coast, and they were often confidence men who would, rip off a few people, very, personal sort of contact with people to try and get their affections and then steal money off them, but not this sort of big scale online fraud. So things have changed dramatically. Organised crime's heavily involved in this. It's violent, it's dangerous, and there's billions of dollars being ripped off. The big thing here that I think is just how impressive the Filipinos are. You know, they've arrested more than 250 suspects in this case alone, and that's the way they take things so seriously. So many other jurisdictions take this much more seriously than Australia. We really are well behind most other jurisdictions. I think the government and the banks particularly haven't really been on the front foot with this stuff. Having said that, there's some new laws coming through in February, which I'll talk about shortly, that show us catching up. But really, you know, countries like the Philippines have been ahead of this, and other countries have been ahead of this for a long time. Authorisations, these are very uneventful. These are really the finalisation of draft determination for the previous month. So Tabcorp, this has been around for ages. Tabcorp runs the Super Tab Totaliser pool, big pool, and other tab organisations come in and join it. And now they just really wanted the West Australians to come in. And there's a lot of public benefits here. Clearly, you know, you're sharing risk over a larger pool, your efficiencies. There'd be a lot of benefits arising from this public benefit. So that was I was going to get approved, and letting a new group in the West Australian organisation was never going to be a problem. Second on BP rewards, this is also a reauthorisation. Been around for a long time. BP offers a BP rewards, and that conduct could be well, it's still enforcing, okay, but it also could have a possibility of substantially less competition given BP is pretty big, so it needs to be authorised, and clearly it deals with fuel and non-fuel offers. Well, that's probably what it always dealt with. The main thing that's changing is, you know, new participating BP resellers, new BP sites. And one thing they did mention was obviously it's based very much on, you know, fuel, you know, petrol, diesel. So the job changed around a bit because a lot of people are now driving electric vehicles. So just acknowledge that that's a change in the market. Notification. So the way this works is if you are wanting to do a collective, say, buying network amongst competitors, you can apply for a notification, send it to the ACCC. They have a period of time to look at it, and if they don't tell you there's a problem with it, it's approved automatically. And that means you can't get sued by the ACCC, you can't get sued by anybody. So it's a pretty significant thing. The main thing is these rarely get reported on by the ACCC in media releases. I've got a theory as to why they did that here. But this involved the Toowoomba City Aerodrome, and there was this group of tenants who decided to speak to the aerodrome collectively through the Toowoomba City Council Community Aerodrome Incorporated, which is a mouthful. So effectively, this organisation, the TCCAI, can go along and talk to the aerodrome and have one negotiation with them and try to work out all the issues with pricing and common lease terms in relation to hangar lease agreements. So you can just imagine the public benefits arising from this collective bargaining. Obviously, it's one negotiation. It'll be a common price. It'll be common terms, and it'll be over very quickly. If there's 20 tenants, the alternative is, you know, 20 sets of negotiations, 20 different sets of pricing, 20 different sets of terms and conditions. Got to draft up 20 different contracts. As you can imagine, it's going to save everybody a lot of time and money. So that's a very beneficial thing. Participation is voluntary. So that means aerodrome doesn't have to agree. They can say no, I don't want to do it, and nobody has to join the collective bargaining group, or they can leave. If everybody's forced into it, that changes the dynamic a lot. And if there's a boycott, if there's permission of the collective bargaining group to boycott the supplier, the aerodrome, that's a much more serious outcome, and there'd be a lot of public benefit to justify that. The ACCC is a bit reluctant to do that. The reason I think this got press release is because maybe the ACCC is thinking of trying to encourage other tenants and other airports to do something similar, where there's huge amount of market power, like Sydney, Melbourne, Brisbane, lots of market power, and it'd be very sensible for tenants there to sort of do a similar thing, get together with you know, set up an organisation that can be its bargaining agent, go in there and maybe do better if they bargain collectively. So I think that's why maybe the ACCC drew attention to this particular notification. Access. Well, this is unusual. 2 access agreements in 2 months. The other was the Australian Rail Track Corporation previous month, and that's one that's clearly it's regulated, and they have to have you know, details of how they're going to negotiate with people, access pricing, deal with disputes. They've got to have all that. And the previous undertaking they had coming to an end, so they had to have a new one. It was pretty routine, and that went through without a hitch. This is different. Unity Group is in trouble because they have been a bit naughty by the looks of it. Effectively, what's happened, the ACCC has issued binding rules of conduct because Unity offers what they call a regulated wholesale service. So they're offering superfast broadband access service, SBAS, and so it's a regulated wholesale service. So you've got to actually be offering terms that are reasonable, that give you a reasonable rate of return on your capital invested and all the rest of it. And if you don't, boom, you can be hit with some binding rules, and B, you could be subject to some access undertakings. So here the allegations are spelled out down the bottom there that several retailers, I guess, expressed concerns, but they complained about the commercial viability of the interconnection arrangements that Unity Group had specified for those retailers to access its regulated wholesale service. So they're just charging them too much. And these guys, if they buy the service, can't compete in the downstream market. So they've complained. And the retailers were also concerned that if they didn't get, wouldn't agree to the price, couldn't get the price they wanted out of Unity, they had to go to the commercial charges rate, which is much higher again. So Unity has been charging too much, and now the ACCC is intervening. I think if they were sensible, they'd sort of come to the party and realise they've got to drop their prices and got to make some reflection of their cost of capital and the rest of it. But who knows? Maybe they just dig their heels in and stick to it. But it's not looking good for Unity if they keep behaving this way. If you're in a regulated wholesale service, you've just got to play ball, really. Next one, gas inquiry report. Only one report this month, but it's a big one. This is been going up and down a bit like a yo-yo. The pricing has been identified, but the main thing is the surpluses and expected maybe deficits of gas on the East Coast market. In previous reports, they've been concerned there was going to be a shortfall, which means Australian businesses who use gas can't get gas. And I guess the news in the current report is there look like there's going to be forecasts in 25, 26. But I guess the big observation here is that we just got a structural problem. We're not discovering enough new gas. So gas production has declined. We've got to find more gas, and then we've got to build more infrastructure to move the gas around. At the moment, there's a lot of gas in Queensland, and there's not really that much industry in Queensland. So you've got this problem where the gas is up north and all the industry's down south, and so you've got to ship it down through pipelines. That adds cost, delay, and the infrastructure's not up to it. So it's probably a role for government to step in here and try to get more gas production and more infrastructure built. As you can see down the bottom there in the middle paragraph, the southern states are already facing seasonal shortfalls and dependent from gas being transported from Queensland. So that's not only uncertain, obviously, but it increased their costs. So the estimates in this particular report are 77 to 112 petajoules surplus in 2025, and then 2026 a decline from 54 to 99. The thing to realise here is that this has been going up and down. So it's looking okay now, but who knows, in a few months' time it could go the other way. Now, this is a very concerning aspect that they found in their report. While the ACCC said there wasn't a systemic problem in the retail pricing practices of retailers, but it appears that some of them are behaving badly and breaking the rules. Some sellers are offering short offer validity periods and insufficient information on charges, terms and conditions. And so what they're saying there is they're going to the market and saying, oh, here's an offer, but you've got to accept it in this short time frame. And the local guy's going, well, I don't have time to really look into this and work it all out. It's expiring. So that's clearly not consistent with their obligations under the relevant code. Also, if you give a customer insufficient information on charges, terms and conditions, how they're going to work out whether it's sensible to enter into a contract. So these seem to be ways of trying to set up customers so that they aren't in a position to accept the offers, and then the retailer can say, oh, we made an offer, we've complied with our obligation. They haven't really at all. And so the ACCC has to step in here and start taking enforcement action against these retailers who engage in this conduct. The thing I like there is they say at the end, they're continuing to fall short of what would be expected in a well-functioning retail market. And it is a better example of a non-well-functioning retail market than the Australian gas market. I don't know what it is. This is what you'd expect in a market that really isn't operating well. It operates like an oligopoly, and it's very concerning. And a lot of cross relationships between different players in the markets, which is not helpful. So I think the ACCC needs to step in and So Scott Gregson is leaving the ACCC and moving to ASIC, and I've got to say, not to blow my trumpet, but Scott Gregson used to work for me 30 years ago for 1 week. I remember he came to me as a brand new graduate, and he was working for me for 1 week, and then he got promoted. So that tells you a bit about the guy. He's very capable, and he moved up very quickly through the ranks at the ACCC. And I didn't work for him. I'd left when he became CEO, but from all accounts, I heard he does a very good job. It's a very difficult job, and I think he did it very well by the sounds of it. A bit nervous about him going to ASIC. ASIC's bigger. It's got a lot more money. It's a lot more complex organisation. All things you can deal with. The main thing I think is problematic is that people have so much animosity towards ASIC, particularly politicians. Like, it's just quite remarkable the vitriol that some politicians aim at ASIC, and he'll be the front man having to deal with that. And so that's I guess the main thing. ACCC. We when I was there, we were very popular with government. We did MUA and GST, and that really put us in good stead with at least the coalition government. But I think we had a charmed run with government, and I think that continues today. The government seems to love ACCC, but now Scott is going to be in the firing line of those economics committees and budget estimates, and I think he'll do well. I guess I included that little video there, Rugboots. This was a case that I ran a few years ago with Nick Xenophon, and it's still going. I might talk about that later on in another podcast, but effectively I wrote Nick some questions, and then he sort of fired them off at the ACCC, and he started off with Rod Sims, Nick, and then he turned his attention to Mr. Gregson and gave him quite a bit of a drilling, and he came up with it very well. I think he's a cool customer, and I think this probably bodes well for him next time when he's ASIC CEO and he's in the budget estimates getting grilled by politicians. I think he'll be able to deal with it quite well. The other person who's leaving, Marcus Betsy, he's a person who I worked with at the AGS many years ago, and then he went to the ACCC Executive General Manager. But then I think the pinnacle of his career, he got asked to lead the group as the Chief Advisor to the Competition Task Force, effectively advising the Treasurer and the government. And so he's been doing that for a while. He's been very busy, doing a lot of great stuff. We've got the merger laws through in 10 months, remarkable achievement. And so he'll be announced, I think, at the Gilbert and Tobin podcast recently announced that he'd be retiring in May this year. So it's a big loss, because I guess after that stint at the Chief Advisor of Competition Task Force, people expected he'd come back to the ACCC, but now he's going to be retiring. And he's a very good guy. I know him well. Worked with him back as senior executive lawyer at the AGS. He worked with me on the waterfront case. I had him and Ben Obridge, two main AGS guys there, and a bunch of barristers, a dozen barristers. So it was a big case, and I really enjoyed working with him. He did a good job. A bit dangerous, but he did a really good job. He did come to my wedding, and this might sound a bit strange, but he moved me. When I became a lawyer, you have to get somebody to move you and say, this person becomes a lawyer for New South Wales. And so he moved me. So I do know him very well. So these are big losses for the ACCC. Scott's been there for 30 years. Marcus has been pretty much there and thereabouts for, a long time as well. And so losing these two people is going to be a big hit for both of them, both for the organisation. A commentary, I think ultra-tune contempt case, very interesting. It's also a case that highlights the importance of getting your compliance program right, making sure you do comply with obligations. And I think staying away from any advisors or independent experts who are going to give the light touch audit, I think stay away from them if you don't want to get done for contempt. Marscale litigation's big stuff, and it's going to be a very long, drawn-out case. Not going to run to 2026. I think there are going to be a lot more interlocutory skirmishes along the way. And I guess it makes sense, because if ACCC is successful there's going to be very large penalties. So they've got to fight to the death on that one, kind of, so to speak. No real risks or problems with the enforcement trends of competition case. I think the ACCC's had a quieter period in recent times, but I think that's probably just due to the selectivity of Gina Cascodley, making sure they're cases she can win, that are important, that are going to have a big market impact. So I'm pretty sure when we see some more competition cases coming through, they're going to be important cases. Romance scams, very good work by the Filipino authorities. I've got to say, it does really draw out how far we are behind in Australia in dealing with this issue. It's very disturbing that we're not, more advanced in defending Australians from getting ripped off by scams. Gas inquiry, that's a problem as well. I'm not too sure about whether it's going to be surplus 25, 26. Who knows? It can change radically and very quickly. But I think the big thing is going to be some legislative involvement there. I think just trusting these retailers to do the right thing is a bit naive. They're not playing by the rules in terms of the offers they're making. So it might be just necessary for the government to mandate a amount of gas that has to be reserved for Australian manufacturers. Just do that. Boom, simple. Departures from ACCC, very significant departures. ACCC will, I think they'll have trouble filling maybe the ACCC CEO role internally. I think they'll have to go external. I've thought of a couple of people who I think do a good job, and I'm encouraging them to apply, but that'll be interesting to see who the next CEO is. Marcus's job would be hard to fill externally, I think. I think somebody internal had to step in that role. It's sort of got, I think, quite a lot of policy type work involved in it. So I think it'd be hard to get someone externally. So that's all I had. Hopefully that's been helpful. It was a quietish month. I've still gone 30 minutes, but I guess there's some interesting things happening. If you have any questions, feel free to give me a call or drop me an email.